Welcome to this explainer on Minnesota's specific notary rules. I am absolutely thrilled you're here because today we're untangling a topic that honestly causes a surprising amount of confusion for new and renewing notaries in the state. Whether you're looking to stamp your very first document down in St. Paul or you're a seasoned pro verifying your compliance up in Duluth, understanding your legal obligations is just absolutely foundational. We're going to break down exactly what the state demands of you, separate the facts from the common myths, and look at how to properly secure your commission in the land of 10,000 lakes. We've got a highly structured presentation ahead of us that's going to make this entire process crystal clear. So let's get into it. Okay, let's dive into this and start with the absolute most surprising number you're going to see today. If you're wondering what the mandatory surety bond amount required to become a legally commissioned notary public in the state of Minnesota is, well, that number is exactly $0. Yep, you heard that right, zero. While a ton of professional licenses and commissions across various industries come with these hefty mandatory bonding requirements right out of the gate, Minnesota completely exempts its notaries from this financial prerequisite. You are not required by the state to post any bond amount whatsoever to get your official stamp. And honestly, this is often a massive relief for folks looking to start their notarial journey because it completely removes a significant upfront financial barrier. To understand why that zero is so significant, we kind of have to look at a very common myth. You see, there's this widespread misconception out there that every single state in the U.S. demands a notary bond before you can start stamping documents. And, it's incredibly easy to see why people might think that, primarily because a majority of states actually do require one. But Minnesota operates completely differently. It's actually one of only 22 states that do not require a notary surety bond as a mandatory part of the commissioning process. By giving notaries this exemption, the state heavily streamlines the initial financial burden of applying, which basically gets you working faster. However, and this is a big however, as we'll explore in depth shortly, the absence of a state-mandated bond entirely changes how you need to think about your own professional liability and risk management. Now, we always want to ground our understanding in the official rules, right? This exemption isn't some random loophole or a temporary waiver. It is directly written into the law. Minnesota Statute Section 358.01 is the official legal authority governing notary requirements, and the licensing authority executing these laws, that's the Minnesota Secretary of State. So when we say you don't need a bond, this is coming directly from the top levels of state government. It's the official protocol under state law, which should give you complete peace of mind that skipping a mandatory bond application won't suddenly derail your commission down the line. It's really foundational to how Minnesota has structured its business and licensing framework. Basically, they're trusting notaries to handle their own protections, which, of course, places a pretty high level of personal responsibility on you as an official witness. But just because the bond requirement is waived, well, that doesn't mean there aren't strict hurdles to clear. Let's walk through the actual application steps required to get commissioned. First up, you'll need a fully completed notary public application submitted directly to the Secretary of State, along with the corresponding application fee. You also have to provide solid, verifiable proof of your residency and overall eligibility to serve. Furthermore, the state conducts thorough background checks. And guys, the gravity of this step literally cannot be overstated. You must have 0 felony convictions on your record to qualify. The state essentially trades the financial security of a bond for the personal integrity of the applicant. If there's a felony on your record, the application stops right there. It's a rigorous standard, but it's designed to maintain the public's trust in the notarial process. And finally, always make sure to check with the licensing authority for any current education or exam rules. Regulations can update, and these administrative steps, combined with your pristine background check, are what ultimately grant you your official authority in lieu of a financial bond. So once you've successfully navigated that rigorous application process, paid your required fees, and passed the eligibility and background checks, your hard work absolutely pays off. The state of Minnesota grants you a notary commission term that is valid for exactly 5 years. That is a solid half-decade block of time where you are officially authorized to perform notarial acts across the entire state before you even need to worry about the renewal process again. 5 years gives you a fantastic window to build your business, establish client relationships, and truly settle into your role as a trusted public official in Minnesota. Which brings us to a fascinating turning point in our explainer. If the state of Minnesota doesn't require a bond, how do you protect yourself? This is where we really have to shift our focus from state minimum requirements over to your personal liability. Because the state isn't forcing you to carry a financial safety net. Any mistake, omission, or fraudulent act that occurs under your stamp could leave you personally completely exposed. Look, state exemptions make it infinitely easier and cheaper to get licensed initially, for sure. But they offer absolutely zero protection for your personal bank account if a legal dispute arises over a document you notarized. Think about the gravity of the documents you're handling: mortgages, wills, power of attorney forms. It's huge. A single clerical error on your part could result in thousands of dollars in damages for a client. And without protection, they're going to look directly to you for compensation. And this is exactly why a vast majority of successful professionals in Minnesota choose to go far above and beyond the minimum state mandates. Even without a mandate dictating it, many Minnesota notaries proactively purchase voluntary protection options to thoroughly cover their legal blind spots. These generally fall into two distinct categories: errors and omissions insurance, which is commonly known as E&O insurance, and a voluntary surety bond. Let's look at why a smart, proactive notary might eagerly invest in these tools even when the Secretary of State doesn't actually require them to. Ultimately, it all comes down to risk management and recognizing that just because you're legally allowed to operate doesn't necessarily mean you're financially safe to operate. Now, what's really interesting about this slide is the distinct difference between these two products. It is absolutely crucial to understand who is actually being protected here because the distinction changes everything. A voluntary bond protects the public. Some notaries purchase this simply to build client confidence, showing they have a formal financial guarantee backing their work. It basically tells your clients that if you make a mistake that harms them, there's a fund available to make them whole. However, errors and omissions insurance protects you. E&O is explicitly designed to cover your legal defense and settlement costs if you're ever sued for a notarial mistake. So one product essentially builds trust with your clients and the public, but the other builds an absolute fortress around your personal assets, your savings, and your livelihood. So the crucial point is understanding the actual mechanics of how a bond functions if things go wrong. This is an essential compliance detail every single notary must know, especially those electing for voluntary coverage. If a valid claim is made against a surety bond, and the surety company pays out to the harmed member of the public, the process absolutely does not end there. The surety company will seek full repayment directly from you, the notary. Let me repeat that. You have to pay the money back. A bond is not traditional insurance for you. It's effectively a line of credit guaranteeing your work to the public. And this brilliantly illustrates why relying on a bond alone, even a voluntary one, can be incredibly dangerous for your finances, and exactly why carrying E&O insurance is so absolutely necessary to truly protect yourself against the heavy, crippling costs of notarial errors. Well, we have covered a tremendous amount of ground today, from Minnesota's unique $0 bond requirement to the vital, foundational difference between a public guarantee and personal protection. If you're ready to secure your voluntary bond or seriously explore your protection options, you can get your notary surety bond quote in minutes. Apply online, fast approval, all 50 states at https://buysuretybonds.com. As we wrap up this explainer, I want to leave you with one final, deeply important thought to consider as you step into your 5-year commission. Look closely at the sheer legal weight of the documents you'll be stamping every single day, and ask yourself, does your current coverage truly protect you from the immense liability you face?